Who is Ricky Brown? You are Graves? You are Graves. And you are Thomas. Switch places for me, so I don't. Okay. Gentlemen, all of you are charged with racing on the highway. You're facing up to 6 months in jail and or a $2,000 fine.
Welcome back to the channel. And today's courtroom session is intense. We're stepping into a Texas courtroom featuring multiple defendants charged with racing at over 100 miles per hour, a no-nonsense judge, and a rapid sequence of criminal cases ranging from reckless highway speeds to domestic violence to full-on intoxication crashes. This isn't just a routine docket. It's a chain of back-to-back consequences, life-altering warnings, and a judge who refuses to hold back. You're about to see 3 drivers accused of racing down a Houston freeway, a defendant who admits he planned to come back later after striking a parked truck, 2 different domestic violence cases with disturbing repeat behavior, and a DWI suspect accused of fleeing after blowing through a red light at nearly 90 miles per hour. The energy is high, and the judge makes one thing undeniable. If you drive recklessly, you can lose your freedom, your license, or even your car within
Going to do
minutes.
probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge.
Please.
The nature of this case is a racing on a highway case, so I just want to let you know that these dim summaries will be separate for each defendant because they were
This
stopped.
moment is huge. A defendant openly admitting to racing is incredibly strong evidence for the state. In most cases, officers rely on observation, radar, or video footage, but a direct admission removes doubt. And here, all 3 defendants not only return to the scene, but acknowledge racing. That eliminates common defenses like, "I was just speeding," or "You misread my driving." When everyone involved admits participation.
Different locations, if that makes sense. Okay. On April 17th, 2025, in Harris County, Texas, an officer was on routine patrol when he observed a Silverado pickup truck and a Cadillac motor vehicle accelerate at a high rate of speed side by side in an attempt to outdistance one another. The officer observed a third vehicle.
This judge issues one of the clearest warnings you'll hear in a misdemeanor court. When he says it's extremely easy in Texas for the state to seize a car involved in racing, he's not exaggerating. The law allows officers to confiscate vehicles tied to repeat racing offenses. Imagine losing your vehicle, not because you wrecked it, but because the state legally takes it. The judge's message is simple.
Dodge Charger increasing speed while following the other 2 motor vehicles. The officer accelerated approximately to 108 miles per hour in an attempt to catch up with the 3 vehicles. The officer noted the posted speed limit on the roadway was 65 miles per hour. The officer notes that he was traveling at 101 miles per hour, maintaining view of the vehicles and recording the incident with his dash camera. The Cadillac and the Silverado truck exited the freeway, and the officer got right behind the pickup truck and paced it, traveling 85 miles per hour. A traffic stop was conducted on the Silverado, and the defendant admitted to the officer he was racing with the other individuals. While speaking with the defendant...
We're talking about Brown, right?
Yes, Your Honor.
Okay.
And while speaking with the defendant, the other 2 vehicles arrived on scene and admitted to the officer that they were racing along with the defendant. I guess that covers that.
Who came and admitted?
It says the other 2 defendants.
The other 2 came in.
This line hits hard. Cities like Houston have seen a rise in fatal crashes tied to reckless driving and street racing. Judges witness the aftermath. Shattered families, severe injuries, and tragic losses. So when he says, "Don't contribute to it," it's not a speech, it's a plea. He gives them 30 days to hire lawyers, comply with bond terms, and stay far away from...
Yes, Your Honor, that's what it states. I'd be happy to read the other.
I'm going to find that there's sufficient probable cause to go forward with your cases, gentlemen. Let me tell you now that the state of Texas and the wisdom of our legislature has made it extremely easy for district attorneys across the state of Texas to seize and take cars from those who are arrested for racing. I have had cases in here where they have seized and taken a car from someone who was caught multiple times participating in this type of behavior. Don't
This
do it.
statement is nearly unbelievable. The defendant admits he knew he hit a parked truck, but planned to return later. In hit-and-run cases, intent is everything. Leaving the scene, even briefly, without exchanging information, already violates legal requirements. Here, the defendant supplies the state with his own incriminating statement. The judge's frustration is obvious, especially given the license situation. Poor decision-making in a minor crash raises concern.
Do you understand?
Yes,
If I find that you do, the first thing I will do is I will put you in jail, and then I'm going to take your ability to drive away from you while this case is open. Living in a city as big as Houston without the ability to drive blows. Do you understand? Each of you, none of you participate racing, street takeovers, donuts, reckless driving, driving maniacally, or putting others' lives in danger. Do you understand? If I find that you're driving at 100 or something like that, it's just not going to go well for you guys. So do you mind filing conditions on each of, no racing, reckless driving, takeovers, anything of this nature, please?
Yes, Your Honor.
And then also, let's go through each one to see if they have valid licenses.
Yes, Your Honor. For defendant, Thomas, we do have an eligible license.
Okay. Also, each of you you're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must have car insurance. If you
This
don't,
case shifts sharply into violence. Visible injuries like bleeding carry major weight in domestic violence charges. Police typically only need injury plus a credible statement to proceed. What's alarming is the timing. This defendant allegedly pled to another assault just 6 weeks ago. Judges don't ignore patterns, and this one is clear. Combine alcohol, a fight in an Uber, and another altercation at home, and the risk becomes undeniable. The judge's conditions.
have either, you are not allowed to drive.
For defendant Brown, we do have an eligible license as well.
Okay.
And then for defendant Graves, the license is eligible.
All right. Gentlemen, do you have the ability to hire a lawyer, Mr. Brown? Okay. Do you have the ability to hire a lawyer? Okay, we're going to give you time to go hire a lawyer. We're going to give you 30 days. When you come back, please have a lawyer. I'm going to have you each go to Victoria, sign a reset. Then we will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. We have enough death on our streets. Don't contribute to it. You understand?
Sure.
All right, come on, guys. All right, you were Jose Castillo.
Yes, sir. Oh.
Mr. Castillo, you're charged with failure to stop, give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you. The defendant was driving westbound on 9100 Willow Meadow at approximately 7 p.m. and crashed into a parked white Chevy Silverado. The defendant's right side mirror struck the left side mirror of the parked pickup truck. The complaining witness identified the defendant's vehicle with surveillance video and rode around the neighborhood until he located the vehicle. The complaining witness gave the address to the officers who went to the location. They met with the defendant, who stated he was aware he hit the truck, but was going to go back later.
Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. You run this license, please.
Yes, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance. If I find that something like this happens again, or if you pick up a new case or become a danger, I will revoke your bond and put you in jail. Do you understand, sir?
Yes, Your Honor. It's eligible, Your Honor.
Okay. Mr. Castillo, do you have the ability to hire a lawyer? Okay, we're going to give you time. I'm going to have you go to Victoria, sign a reset. We will have you take a seat in the jury box while I get your bond conditions. When you sign it, then you'll be free to go. Please.
All right, Judge, page 5, Contreras. Come on up.
Sir, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you.
Another domestic violence situation, and it escalates quickly. Recording arguments, fighting over a phone, and then allegedly punching the complainant before attempting to hit him with a scooter. This is serious. When the judge issues a magistrate's order of emergency protection, it means the court sees an immediate threat of future harm. Violating such an order can result in one of Texas's harshest misdemeanors, often with mandatory jail time. The judge requiring the defendant to secure employment.
The defendant and the complaining witness were in an Uber on April 17th, 2025, when a fight broke out. The defendant jumped on top of the complaining witness. The complaining witness and the defendant were dropped off by the Uber driver at the complaining witness's house. Once at the property, the complaining witness attempted to go inside. The defendant started a physical altercation where he struck the complaining witness with closed fists, causing pain and injury to the complaining witness. The complaining witness was able to get away from the defendant and lock the door with the defendant outside. The complaining witness has visible injury and bleeding of the face observed by officers who arrived on the scene.
Relation, and is there alcohol or dope involved? Just pled to an assault a month and a half ago, and here we are again.
Your Honor, the nature of the relationship, it states as a roommate of 2 weeks, and they were at a club known as Wagos on Washington Street. And Your Honor, according to the dim summary, the complainant stated the defendant got too drunk.
We are now going to handle whatever issues that are arising with you. If I find that you're another danger to the community, I will put you in jail. You're ordered not to consume alcohol or illegal drugs, and I'm going to put an ankle monitor on you so I know that you're not consuming. You are not allowed to go to bars, nightclubs, anything of this nature where alcohol is primarily sold. Do you understand? So I'd like to put a scram on him. Okay, yeah. Waive the fee. You're not to have contact with the complaining witness in this case. If I find that you do, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? What do you do with yourself these days?
I'm taking care of him. Stepdad has taken away everything from us. So we're trying to figure that out. And that's why I'm moving with Chris.
It's time for you to get a job. And I'm making that a condition of your bond. You're not doing anything and you have way too much time on your hands, so you're becoming self-destructive. This is now your second assault case within the last month and a half. No more. Do you understand?
Sir,
Can you reach out to the MAC for him, please? And then you're not to be in possession of weapons as well. I'm going to have you go to Victoria, sign a reset, and then we will have you take your seat in the jury box. You're going to have to get with them for your bond conditions, then we'll get you a lawyer soon. Good morning, Mr. Crenshaw. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. An officer met with the complaining witness who stated that the defendant has been staying with him off
This
and on.
DWI case is extremely serious, running a red light at nearly 90 miles per hour, causing injury, and allegedly attempting to flee. These facts can push a misdemeanor toward more severe charges. Refusing field sobriety and breath tests forces officers to request a blood warrant. And lab-tested results are usually strong evidence. The judge's conditions, no drinking, random testing, and limits on driving, reflect how dangerous the situation was. What stands out?
The complaining witness advised that he came home and found garbage in the apartment, which the defendant denied having done. The complaining witness stated the defendant started recording him, accusing him of threatening the defendant. The defendant then put the phone in the complaining witness's face and the complaining witness took the phone, at which point the defendant punched the complaining witness several times in the face, causing pain. The defendant then attempted to take an electric scooter, which eventually struck the complaining witness in the leg, causing pain. The officer observed the complaining witness to have multiple injuries on his face.
All right, Mr. Crenshaw, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with the complaining witness in this case and not to be in possession of any weapons. You understand? I don't see that a MOA or a protective order has been issued. Do you? You see a tray protective order?
It was stipulations of my bond. I know that.
On Crenshaw, okay. I'm now entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Mr. Montgomery as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes, sir.
If you violate this court order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up.
Yes, sir.
Do you understand? Do you have the ability to hire a lawyer, Mr. Crenshaw? Do you work?
Yes, sir. I'm currently looking for a job.
Okay, it's time.
Yes, sir.
We're going to make sure that that happens. So 2 weeks, I'm going to bring you back and I want to see what you have done to get a job. If you've done nothing, it's not going to go well for you.
Yes, sir.
You understand? All right. I'm going to appoint you a lawyer. I'm going to have you go to Victoria Center Reset. We will have you take a seat in the jury box. I'm going to get you bond conditions. Do not leave until you sign them.
Yes, sir.
You're not to have contact. You're not to be in possession of weapons. You understand?
Yes, sir.
Come on.
Let me take it.
Oh, hold on. Come sign for your protective order.
All right, Judge, next is page 6. Easy.
Hey, can you file the no contact of weapons, please, on that? Mr. Crenshaw? Okay. Good morning, Ms. Woodward. Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Okay, Your Honor.
On April 17th, 2025, in Harris County, Texas, the law enforcement officer made contact with the complaining witness who stated that she had a green light and the defendant's vehicle struck her on the driver's side. The complaining witness was transported to the hospital. A wheel witness stated that he saw the defendant driving at approximately 90 miles per hour and run the red light and hit the complaining witness's vehicle. The wheel witness followed the defendant and the defendant stopped a few hundred yards away from the scene. The wheel witness stated that he believed the defendant was attempting to flee, but only stopped due to mechanical issues with his vehicle. The law enforcement officer came into contact with the defendant and noticed slurred speech, an odor of alcoholic beverage, red bloodshot eyes, disorientation, and inability to follow instructions. The defendant admitted to driving. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, and the defendant refused the walk and turn and one-leg stand. The defendant also refused to provide a specimen. A blood warrant was obtained and a blood draw was executed.
Jesse, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand? Can you look to see any prior DWIs and if he has a license, please?
And that wraps up a stacked courtroom session. Racing cases, hit and runs, domestic violence incidents, and multiple DWIs, each demonstrating how quickly reckless decisions can spiral into major legal and personal consequences. From strict warnings about seizing vehicles to bond conditions limiting alcohol, driving, and contact with victims, the judge's consistent theme was clear. Public safety always comes first. Whether it was the drivers hitting 108 miles per hour, the defendant who left the scene of a crash, or the violent disputes inside homes, today's proceeding showed that accountability isn't optional. If this case shocked you as much as it shocked us, hit like, drop your reactions in the comments, and subscribe for more intense courtroom breakdowns every week. Stay smart, stay safe, and we'll see you in the next one.